What is the future of marriage in the United States as a civic institution? Specifically, what is the future of marriage law now that the Supreme Court of the United States has held that all 50 states must redefine marriage? Or put differently, now that marriage is no longer the union of a man and a woman, what is it going to be? How is it going to be defined in law? What will be the norms of marriage in law? This is a question that the Supreme Court did not give very serious consideration in its Obergefell ruling, even though the briefs, many briefs filed with the court, provided resources to explore this question, briefs that drew upon philosophy and made the observation that if marriage is not defined as man and a woman, there's really no limiting principle as to how it should be defined. If it's just any group of people who care for each other, then any group of people who care for each other have a claim in justice to be married. Social science evidence can tell us about family structures and the well-being of children and the correlation between a child being raised in an intact biological family and that child's well-being as compared to other family structures. And public law theory can tell us a lot about the future of marriage. So, for example, the legal philosopher Sharif Girgis has argued, persuasively I think, that if marriage is no longer the union of a man and a woman in public law, if public law is now going to teach that only bigots think that marriage is the union of a man and a woman, it seems reasonable to infer that people will no longer publicly admit that they believe marriage is the union of a man and a woman, and that people will act accordingly, and that this will have a corrosive effect on marital norms. My own approach to the question is through private law and private law theory. I became interested in the question as I was serving as a Special Deputy Attorney General for the state of Alabama, advising the Alabama Attorney General and the Governor about the constitutionality of Alabama's marriage laws. And at the same time, I received a paper from a friend of mine, political scientist at Louisiana State University, James Stoner, who pointed out that the duties of parents toward their natural children in fundamental law have persisted despite changes in family law over the last 50 years or so. And this got me interested in the question, what's going to become of all those incidents of marriage and parentage in our fundamental laws, which are designed, purposed toward the well-being of children, the natural duties, securing the natural duties of parents toward their natural children. Things like the presumption of paternity, which can have no application to a man-man couple and can only apply to a female-female marriage under certain circumstances. The prohibition against incest, which of course is designed, justified on the basis of its protection of children, but of course on that justification can have no application or only arbitrarily to a same-sex couple. Other incidents such as the presumption of biological parental custody, the due process rights of fathers not to have their parental rights terminated without a showing of cause, presumptions of kinship custody, and so forth. And if you look at the laws of states that have redefined marriage some time ago, I think it's interesting that these norms persist. These fundamental rights of children to be connected to both a mother and a father, and in particular their own mother and a father, are persisting even where marriage has been redefined. And I think there's a lesson to be drawn there about the future of marriage law in the United States. And that's what this article is about.